Good morning. Welcome to the final round of the 56th annual Roger J. Traynor Moot Court Competition. I'm Miriam Billington. I'm the administrator of the Traynor, and this is how the session will work today. I'm about to turn over the proceedings to our esteemed bailiff, who will introduce our panel. At the end of the argument, the justices will confer offline outside of the Zoom, and I will be here to make some awards and thank yous. And then the justices will return and announce the winner of this year's Traynor. Acting as our bailiff this morning is Professor David Glassman, a decades-long supporter of this competition. For the purposes of this session, David Glassman and I are not affiliated with either team competing here this morning. With that, I thank everyone for coming, and I turn the proceeding over to you, Professor Glassman. Thank you.
Thank you very much. This is a session of the California Court of Appeal, Second Appellate District, Division 9. The presiding justice in this matter is Justice Terry Cody. Joining her on the bench for today's session are Justices Timothy Weiner and Gary Shans. The case before the court is the people of the state of California versus Peter Prescott. Each team has a total of 30 minutes. We will begin with the first counsel for appellant, Elizabeth Milks. Ms. Milks, you have requested 15 minutes. You may proceed when you're ready.
May it please the court, my name is Elizabeth Milks for the appellant, Mr. Peter Prescott. I will be addressing Mr. Prescott's invocation of his Miranda rights and the implications that had on the subsequent Perkins operation. My co-counsel, Lillian Dutcher, will be discussing due process and tainted fruit concerns related to the statements made during that undercover operation. Ms. Dutcher will reserve time for rebuttal. Imagine you're in custody. 3 days ago, you were arrested and subjected to relentless interrogation where your Miranda rights were blatantly disregarded and the detective leveraged threats and promises against your future. After you were coerced into making a statement, you were sent to jail and cut off from the outside world. You asked for a phone call several times, but never received one. You were denied a shower, and you were disoriented because you had been moved between cells several times until finally you were placed in a cell with someone who appeared to be a fellow gang member. That person initiated a conversation, asked all the right questions, and suddenly everything that was weighing on your mind while you were isolated the past 3 days came out. In Miranda versus Arizona, the U.S. Supreme Court created procedure.
Counsel, are you arguing that his statement was involuntary?
That is part of our argument, Your Honor. The pressures of the coercive conditions of that initial interrogation, the police misconduct during that interrogation, and the continued coercive pressures of his incarceration before the undercover operation did lead to his statement being involuntary and in violation of his Miranda rights that he had invoked.
Well, I don't recall that factual involuntariness was raised either in the trial court or in your brief.
There was the different conditions created these circumstances that there is a presumption of involuntariness where you have so many coercive pressures weighing on the defendant as there was with Mr. Prescott. And my co-counsel will elaborate on the factors that lead us to the conclusion. And we're also looking in my argument at how the coercive pressures of that interrogation after his invocation of Miranda rights affected the admissibility of his statements during the undercover operation. In Miranda versus Arizona, the U.S. Supreme Court created those procedural safeguards to protect a suspect's Fifth Amendment right against compelled self-incrimination. Miranda requires that prior to custodial interrogation, law enforcement must advise a suspect that he has the right to remain silent and to counsel. Without these Miranda warnings, a statement that stems from a custodial interrogation is inadmissible. And when he invokes his right to silence, the police may later reattempt questioning if there are renewed Miranda warnings. Under Edwards versus Arizona, when a suspect invokes his right to counsel, the police cannot reattempt custodial interrogation without counsel present or a valid Miranda waiver. In Illinois versus Perkins, the U.S. Supreme Court held that law enforcement does not need to give Miranda warnings before an undercover operation. But the facts in Perkins are materially different from the facts in Mr. Prescott's case. And the difference is that the defendant in Perkins did not invoke his Miranda rights prior to that undercover operation. For that,
Counsel, doesn't Perkins take this situation entirely out of the scope of Miranda?
can you repeat that, Your Honor?
Yes. Doesn't Perkins, the Perkins decision, take the statements that he made to the undercover agent entirely out of the scope of Miranda?
Because they were during an undercover operation?
Because they weren't, quote, an interrogation.
Well, we do have an interrogation. It's true that the police may listen to a defendant's voluntary statement while he is in custody, but the moment that law enforcement intervenes in that conversation and asks questions, it does become an interrogation.
But doesn't interrogation require that the individual be faced with police, people who are trying to extract a confession from him, as opposed to a feigned fellow gang member? Isn't that the whole touchstone of the Perkins decision?
It is the holding of Perkins, but here we have an FBI informant, a person who is reporting to the FBI, who is inserted into the defendant, Mr. Prescott's cell, and asks him questions that continually redirect the conversation back to the shooting at the Capistrano Lounge and ask him clarifying and leading questions.
Well, Ms.
He was
Milks,
more
Ms. Milks, how can there be coercion if the speaker does not know he or she is speaking to a police officer or an agent of the police?
Here, because Mr. Prescott's Miranda rights were disregarded to an extent where the district attorney stipulated to exclude them from evidence in the original trial. So we have a violation that's not just an absence of Miranda warnings, but a violation so severe that it was stipulated to be.
Prescott didn't know the statements were being made to a police officer or an agent or anyone connected with law enforcement. Is that correct?
The record is unclear as to who he thought this person was, as to whether he was an agent of law enforcement, but we do know that there were statements. He was never truly released from the coercive pressures of that.
Wasn't it incumbent upon you in the trial court to put on evidence as to who he thought this person was? You're arguing now that he didn't know, so we're going to assume that he thought he was speaking to a law enforcement officer. I'm not prepared to do that.
Because he may have believed that this was a fellow gang member, but none of the case law before us contemplates the impact that it would have for someone who's gone through this coercive interrogation 3 days earlier, been subjected to a continued course of misconduct by police in the coercive pressures of his confinement, and he never truly had a break in custody. He has spoken to no people that have been that he's only spoken to custodial personnel for the past 3 days, and he's disoriented because he's been in isolation until he's put in a cell with someone who initiates a conversation. In many cases, the initiation of a conversation is a key indication as to whether there has been a Miranda waiver.
Ms. Milks, other than the fact that Mr. Prescott was in custody, what other coercion was present at the time he made the statements? Because I think under Orozco, the mere fact of being in custody is not enough. Would you agree?
I agree. And Perkins itself states that custody in a technical sense is not enough to implicate Miranda.
So
However,
here Prescott was in custody and talking to somebody who he clearly did not believe to be a police officer or an agent of the police. So I will agree with you that there was custody present. But other than custody, where's the coercion?
the coercive pressures, because he was subjected to this interrogation, there is a presumption that when you have a Miranda violation, that there's a heavy burden on the government to demonstrate, according to Miranda, that there was a knowing and intelligent waiver after a violation of that he has waived his rights before making another statement. We
So
don't
I'd like to
have-
ask you two questions. Number one, does it matter here that that Mr. Prescott invoked only his right to remain silent when he was interrogated originally, as opposed to his right to counsel? Does that make any difference?
There are different implications in the two invocations of rights. And as I mentioned earlier, when you invoke your right to silence, you may reinitiate questioning. The police may reinitiate questioning later with renewed warnings. And under Edwards versus Arizona, there is the requirement that that counsel is present, or there is a Miranda waiver. Now, Mr. Prescott, the judge found that Mr. Prescott did invoke his right to silence, but in the pretrial hearing, his defense counsel stated that he did invoke his right to counsel as well.
Well, there's no facts to support that, but the other additional fact I'm curious about is when your client made his statement to the undercover agent in jail, had he been charged with the murder at that time?
He had not yet been charged, Your Honor.
Okay.
His arraignment was coming up. So his
All right.
Sixth Amendment
So
right
he
to counsel.
he had not been brought into court, advised of his rights, and invoked his right to counsel, and he hadn't been provided counsel at that point.
Correct. And he
Okay,
had
so the right to counsel has nothing to do with the facts of this case. Can we say that?
There is under People versus Johnson by the California Supreme Court. There is a mixed question of fact and law for this particular review, where the trial court's findings of facts will be accepted if they are supported by substantial evidence, and this court will independently determine whether the statements were legally obtained. But we would argue that there is the possibility that a de novo standard of review would be appropriate, because we have a situation where the determination to exclude the statements.
Well, wait a minute. You're getting off on another tangent. What I wanted you to answer for us, if you could, is the right to counsel not implicated under the facts of this case?
According to the findings of facts, that we encourage this court to consider de novo standard of review to review that initial interrogation to determine whether there was actually an invocation of the right to counsel.
Well, okay, point those facts out to me, if you would.
We have the defense counsel stating that Mr. Prescott invoked his right to counsel, and because of the police misconduct.
Well, that's not evidence.
There is a call out in the record that there may be evidence within that original interrogation, which was not included in the materials of our record, but we would be happy to augment the record and request that to the court clerk if that would be helpful to this court to determine whether that right to counsel had in fact been invoked.
Counsel, do you think Orozco was wrongly decided?
The facts in Orozco were different. What we had in Orozco was a situation where there was a Miranda violation and there was a subsequent admission to an undercover agent of the police. However, in Orozco, we don't see that, as we saw here, that the defendant's will could be overborne by the coercive pressures of a Miranda violation. Mr. Orozco did not confess after the Miranda violation of continued questioning in that initial interrogation, and thus there's more indication that his subsequent admission just shortly after that interrogation was voluntary because his will had not been borne down. However, we have Mr. Prescott here whose will was overborne by Detective Hayford's coercive behavior, and he did make an admission that was unusable, and Detective Hayford was told to go and find another way to get a statement.
So, counsel, are you saying that the statement should not have been admitted regardless of the Miranda decision and its progeny, including Perkins? You're just making a straight factual voluntariness argument, as I understand it. Is that correct?
Correct. Because of the coercive pressures of that interrogation, the fact that we know that the defendant's will was overborne, and while he was released from the coercive pressures of interrogation, he was not released from the coercive pressures of a police-dominated atmosphere because of the conditions of his incarceration.
So Ms. Mills, what was the police-dominated atmosphere? My understanding, based on my review of the file, is that he was in a holding cell of some sort, speaking to a person he believed to be a fellow inmate or someone else who is being held in custody.
Ms. Milks has
The,
2 minutes remaining.
thank you.
So again, other than the fact that this person is in custody, which we know from the relevant authority is insufficient in and of itself, where's the coercion?
The coercion is that for a break in custody under People versus Storm to relieve the coercive pressures that had existed to that point of custody, we know that there must be a sufficient opportunity to consult counsel. And we know that Mr. Prescott did not receive a phone call. We also have a situation where we know he's in custody and he was subjected to questioning by an informant who reports to the FBI. On page 35, that informant says, "Tell me your version of it." This is 40 pages into the transcript where the FBI informant has been continually redirecting the conversation to the shooting at the lounge as Mr. Prescott has gone down different tangents. So we come to this moment on page 40 where he says, "Tell me your version of it." And when Mr. Prescott doesn't answer it evidently to his satisfaction, the next page, the informant says, "No, but when you guys went, how did it go down?" This is interrogation, and Mr. Prescott does make a confession at that point. We have to deter law enforcement from this type of misconduct, where coercion was used to elicit an involuntary admission that was unusable and stipulated to be excluded by the district attorney. And then we have the detective finding a way to circumvent Mr. Prescott's Miranda rights with this last-minute so-called Perkins operation. None of the case law before us contemplates the coercive impact of such a egregious Miranda violation. And for the foregoing reasons, we respectfully ask this court to rule that Mr. Prescott's Perkins statements were inadmissible because he had invoked his Miranda rights and they were disregarded, blatantly disregarded. And we request that this court reverse the judgment of the trial court. Thank you.
Ms. Docher, you have 11 minutes.
Good morning. May it please the court. My name is Lillian Dutcher, and I represent the appellant, Mr. Peter Prescott. May I reserve 4 minutes for rebuttal?
You have, thank you.
This morning, I'll be addressing the issue of what effect the Miranda violative continued questioning of Mr. Prescott after he invoked his right to silence had on the admissibility of his statements obtained during a subsequent undercover operation, and whether Mr. Prescott's due process rights were violated in that scenario. I ask this court to reverse the judgment of the trial court and rule that the trial court erred in admitting Mr. Prescott's Perkins operation statements because those statements were given involuntarily and thus in violation of due process.
Counsel,
Due process demands.
how is your argument different from your colleagues?
The difference in my argument from my colleague's argument is that I will be evaluating the totality of the circumstances under which Mr. Prescott gave his incriminating statements pursuant to the California Supreme Court case of People versus Williams. Specifically, I'm going to get into the specific factors that Mr. Prescott was subjected to that resulted in his will being overborne by official pressure to the extent that his ability for self-determination was critically impaired.
Well, that sounds a lot like your colleague's argument.
Well, what my colleague argued was that there was an implication of his Miranda rights, and thus that tainted his subsequent statement during an undercover operation. She didn't get into the specific factors of what rendered Mr. Prescott's his statements inadmissible, and that's the focus of my argument in this case. The constitutional right to due process is secured by both the California and federal constitutions and mandates the suppression of involuntary confessions given by criminal defendants. The California Supreme Court in the case of People versus Neal ruled that it's long been held that under the Due Process Clause, involuntary statements given by criminal defendants by way of law enforcement coercion are inadmissible in a criminal proceeding. In the case of People versus Montano, the court ruled that disrespect to the right to remain silent is indicative of coercion. In the case of People versus Parker, the court ruled that if a criminal defendant invokes their Fifth Amendment privilege to remain silent, any statement taken thereafter cannot be other than the product of compulsion or otherwise. Here, Mr. Prescott invoked his right to silence, and law enforcement deliberately disrespected his invocation by continuing to question him thereafter. Thus, pursuant to Montano and pursuant to Parker, this is indicative of coercion, and any statement taken thereafter, including his statements during an undercover operation, cannot be other than the product of compulsion or otherwise.
Ms.
What if
Dutcher,
what if he had made the statement to his girlfriend, for example?
Well, what that would depend on, Your Honor, is whether he was in custody and whether the girlfriend was acting as an agent of law enforcement or not. Really, what is dispositive in this case is whether the coercive pressures that he was subjected to over the course of his incarceration rendered his ability for self-determination to be critically impaired to the extent that his statements were given involuntarily.
Let me clear up one thing.
Ms. Dutcher, you had referenced Williams a minute ago, but Williams stands, based on my reading of Williams, it stands for the proposition that when a defendant speaks to a fellow inmate, the coercive atmosphere of custodial police interrogation no longer exists. So doesn't Williams really cut pretty heavily against your argument here?
It certainly may, Your Honor, but what Williams also stands for is the proposition that in the context of an initial Miranda violation, the inquiry with respect to a subsequent statement is whether that statement was given voluntarily. And so for purposes of my argument, the factors that I will be referencing include the fact that Mr. Prescott's Miranda rights were violated on that April 28th interview when he was continued to be questioned after he invoked his Miranda rights.
Counsel,
The fact that during this same interview,
Counsel, how does the violation that you're claiming occurred at the initial interview, how does that have any impact at all on statements that were later made in the Perkins operation?
because pursuant to the case of People versus Montano, Your Honor, disrespect to the right to remain silent is indicative of coercion. And so my argument focuses on whether the coercive atmosphere had a causal relationship with Mr. Prescott's decision to subsequently make incriminating statements in the context of an undercover operation. Another relevant factor to this consideration is the fact that Mr. Prescott was subject to an improper threat when Detective Hayford told him that unless he came off of his invocation to remain silent, he would serve a life sentence.
Well,
The
Counsel,
fact that in that same interview,
let me ask you this. Are you arguing a fruit of the poisonous tree type of theory here or something else?
I'm arguing a similar premise, Your Honor. I'm not arguing that the Miranda invocation alone renders his subsequent statement fruit of the poisonous tree. What I'm arguing is that a pattern of coercion rendered his ability for self-determination to be critically impaired.
So you're not arguing that what he did tell the police in the real interrogation, that you're not arguing that that has any effect upon the admissibility of his subsequent statements?
I'm not arguing that the statements that he
gave during— You're not arguing a cat out of the bag type of theory then?
No, Your Honor, that is not the argument that I'm making today. The argument that I'm making today is that in evaluating the totality of the circumstances, which the California Supreme Court in the aforementioned case of People versus Williams ruled to determine voluntariness, Mr. Prescott's ability for self-determination was simply critically impaired by the time the Perkins agent came into his cell and got incriminating statements. And for purposes of my argument, I will continue to list the remaining factors that are pertinent to this discussion. Mr. Prescott was subject to an improper threat when Detective Hayford told him that unless he came off of his invocation to remain silent, he would serve a life sentence. The fact that during the same interview, Detective Hayford gave him an improper promise of leniency by telling him that if he came off of his invocation of right to remain silent, meaning give an incriminating response, he would be promised leniency. The fact that over the course of the subsequent 3 days, he was deprived of a shower despite repeated requests, which is a violation of California Penal Code Section 2084.5. The fact that over the course of these 3 days, he was also deprived of a phone call when he made repeated requests for a phone call. And the fact that in being deprived of a phone call, he was also deprived of the support and guidance of counsel. When we evaluate the totality of the circumstances during which Mr. Prescott made his incriminating statement, he was subject to a pattern of coercive police activity.
Ms. Dutcher, I'm sorry, Ms. Dutcher, you referenced Penal Code Section 2048.5?
No, Your Honor, one number off.
I'm sorry.
2084.5.
084.5. Okay, thank you.
That is correct. Absolutely. And with respect to the aforementioned threats, the California Supreme Court in the case of People versus Jones held that if a criminal defendant is subject to threats and within a few days thereafter they give an incriminating statement, that statement cannot be admitted in evidence unless the prosecution clearly shows that such improper treatment did not cause the criminal defendant to make the subsequent statement.
Counsel, are you suggesting that the promises of leniency that you talk about made during the real interrogation, that those somehow were in his mind when he confessed to what he thought was a fellow gang member? Did he think he was going to get leniency from that person?
No, Your Honor, I'm not making a connection with the gang member himself. What I'm suggesting.
Wait a minute. Well, okay, hang on though. You've keyed in on the promises of leniency made by the police. How do those promises of leniency have anything to do with the statement he made to a person he thought was a gang member?
Because pursuant to the California Supreme Court case of People versus Neal, the court ruled that promises of leniency, no matter how remote, are corrosive to voluntariness and are coercive. And in the case of People versus Jones that I mentioned, the court ruled that there's a presumption that the influence of improper treatment continues to operate on the mind of a criminal suspect to the extent that his or her subsequent statement is of the same influence which rendered his prior statement inadmissible. In other words, there is a presumption in this case that the improper treatment during that initial interview, during which he was subject to improper threats and improper promises of leniency, continued to operate on his mind throughout the remaining course of his incarceration to the extent that his subsequent statements to the undercover operator were of the same influence, which rendered his initial interview inadmissible.
2 minutes.
Does it maybe I'm misunderstanding what you're saying, but is there anything about the way the conversation that occurred with the alleged gang member that is important in your argument? Because I'm not hearing that when you make the statement that essentially whatever he says after this alleged first Miranda violation is inadmissible. So
when we evaluate
connection with the actual undercover agent and the conversation that they had.
Well, there's a two-part response to that question, Your Honor. And first, that includes the fact that in States versus Henry, the United States Supreme Court said that a defendant's status as in custody during an undercover operation is a relevant factor in determining voluntariness because they're susceptible to the influences while they remain in custody. And then when we couple that with the evaluation of the Perkins transcript itself, it's clear that at the beginning portion of his conversation with the Perkins agent, he was hesitant to speak with the Perkins agent.
Excuse me, counsel. Excuse me. Doesn't the fact show that, in fact, it was your client who initiated the conversation with the undercover agent by asking him what he was in custody for?
No, Your Honor. It was the Perkins agent himself that initiated the conversation, during which Mr. Prescott did, in fact, respond, like you pointed out, that who he was affiliated with. But it was the Perkins agent that initiated the conversation with Mr. Prescott.
Well, okay, but doesn't the course of the conversation indicate that the defendant, your client, knew exactly what he was doing? He was conversing. He's adding facts as he goes along. That doesn't sound to me like he felt he was under some form of coercion or pressure. Where in that's the facts we need to look to, and I don't see the coercion area. You can answer the question if it's.
Thank you, Your Honor. When we evaluate the totality of the circumstances in this case, Mr. Prescott simply couldn't escape any of the coercive pressures. And when we look at the course of his conversation with the Perkins agent, he was apprehensive to respond to any of the continued questioning by the Perkins agent. And pursuant to the case of United States versus Henry, the court said that their status as in custody with an undercover operator renders them particularly susceptible to the subtle ploys of remaining in custody. And for the foregoing reasons, I respectfully ask this court to rule that the trial court erred in admitting Mr. Prescott's Perkins operation statements and that his due process rights were violated thereto. Thank you.
Ms. Mueller-Shaw, you have 15 minutes.
Thank you. Good morning, Your Honors, and may it please the court. My name is Keilana Mueller-Shaw, and I'm appearing on behalf of the respondent, the state of California. Today, I'll argue issue 1, that undercover statements taken after the right to silence is invoked are admissible under Perkins. And my co-counsel, Landy Watson, will argue issue 2 of the case, that there was no due process violation here, and that the fruit of the poisonous tree doctrine does not apply. The questions before the court today boil down to the absence of police coercion. Perkins v. Illinois crystallized the holding of Miranda on this issue. Where there's no pressure from an officer in uniform, any concerns of coercion during undercover questioning evaporate. Here, the appellant openly bragged about his violent acts to the undercover agent. His right to silence did not extend to speaking with someone he believed to be his cellmate. And so we ask this court to join its sister courts in denying this appeal and affirming the admission of the Perkins transcript. Turning to my argument, the rule that we're asking from the court today is that in holding with existing law, a defendant's invocation of the right to silence has no bearing on the admissibility of statements obtained through a Perkins operation.
Counsel, what about the sort of gross Miranda violation that preceded the Perkins operation? How does that factor in here? Your opponents are indicating that that sort of did so much damage that it sent the airplane into a spiral from which it could not recover. How do you respond to that?
Your Honor, the invocation of Miranda rights and the violation of those rights does not bear on the subsequent undercover statements as held by Perkins because the concern of the Miranda court was about the visible pressures attendant to speaking to someone you believe is law enforcement. Further, for this initial legal question, it's about whether the mere invocation of the right to silence dictates categorically that those statements should be excluded. I disagree. I think that's too broad of a rule. I also respectfully disagree with my opposing counsel's contention that the Perkins operation was an interrogation. Perkins explicitly held that undercover questioning is not a custodial interrogation for the purposes of the Miranda.
Do you agree with your opponent that the questioning, though, was instigated by the undercover agent? And does that make a difference?
Yes, Your Honor. I agree that the questioning was instigated by the undercover agent. However, that does not make a difference for the applicability of the Miranda doctrine because it was undercover and the defendant did not know that he was speaking to law enforcement. And so for that purpose, Miranda waiver doctrine does not apply.
So I'm trying to think how far this might go. What if the agent had a bug in his ear and law enforcement was feeding him question by question by question? Would that make a difference?
Your Honor, that would not make a difference because, again, if we go back to the concerns of the Miranda doctrine, the Miranda case, it was all about coercion from the perspective of the suspect. That's a holding under Rhode Island v. Innis. And the reason that's the concern is that when a defendant believes that they are having a private conversation free from any reprisal or hope from leniency that comes with speaking to someone you know as the police, when you don't have that pressure, then you're able to give a voluntary statement.
Is it reasonable for a person in police custody being questioned about a horrific felony to believe that they are having a private conversation? Is that a reasonable starting point for this court?
Your Honor, it's not for me to speak to whether the defendant thought that that was reasonable. The fact is that he did openly have that conversation. And Perkins itself says that it is appropriate for police to take advantage or to use strategic deception to take advantage of misplaced trust. And
wasn't this just an interrogation, a thinly veiled interrogation? I mean, honestly, like the Miranda violation was terrible. So they put him in with an informant and asked the same questions.
No, Your Honor, this wasn't an interrogation for Miranda purposes. It was questioning. It was a conversation with the Perkins agent. But the constitutional question we're asking is how far does the Miranda doctrine extend? And the underpinning of that concern was about visible police coercion, which was not present here. And so for that purpose, it may not be how we colloquially think about what is questioning, what is interrogation, but for the purposes of Miranda, this was not an interrogation. It was an undercover police questioning.
Counsel, let me ask you this: does it make any difference that the defendant here, the appellant, invoked his right to remain silent as opposed to his right to counsel? Does that change anything?
Your Honor, that does make a difference. Opposing counsel Milks brought up Edwards v. Arizona, which was a right to silence case, and it held that there is a more protective standard for getting Miranda waiver in the right to counsel context, because the court reasoned that when a defendant invokes the right to counsel, they're indicating their refusal to answer any questions without the presence of a lawyer.
Well, it actually, what it's saying is I want to deal with the government only through counsel, right?
Sure, yes, Your Honor, that's correct. And here there was the issue that the appellant brought was only with regards to the right to silence. And so Edwards v. Arizona does not apply.
All right, let me further ask you this. Your opposing counsel argued that he did invoke his right to counsel, and the evidence tendered was a statement made by defense counsel in the trial court. What's your response to that?
Your Honor, I don't believe there is evidence to that in the record. Judge Weiler on page B19 of the record held that the defendant never invoked his right to an attorney. But regardless of that dispute, the issue that the appellant brought in this case was solely about the right to silence and not about the right to counsel. So I don't believe it's applicable. Even so, let's say this was a right to counsel case. California courts of appeals have held unanimously that Edwards does not apply when there's a disguised police agent eliciting a confession because it's not custodial interrogation. For example, we talked, I think you discussed earlier with my opposing counsel, People v. Orozco, that was a right to counsel case. The facts to this case are very similar. There was a repeated Miranda violation. And ultimately, the defendant gave a confession to a police agent. In that case, it was his girlfriend. Even there, in the right to counsel context, the court found no Miranda violation. They acknowledged the poor police behavior, but they found that there was no constitutional violation with regards to Miranda and the Fifth Amendment. And that was because the preventive purpose of Miranda was to avoid pressures attendant to speaking with the cops.
Let me ask you this. Let's assume this scenario. You have the same exact facts, except it's 3 days later, and the police go back into the jail and bring Mr. Prescott into a room, re-Mirandize him, and he waives and gives a statement. Would that be admissible?
Yes, Your Honor. If the defendant waives his rights and then gives a statement, the resulting voluntary statement would then be admissible. I think case law is clear on that. Yes.
Was there enough attenuation between his original invocation and now his, being re-advised and waiving?
Your Honor,
we're really talking about a renewed questioning case, which if you buy the appellant's argument, that's what this really is, because they're saying this agent was like the police and they're now back in custody again, right? Or they're interrogating him in custody. So no, there wasn't a Miranda advisal and waiver, but I'm inserting that into the facts and asking you, would that statement now be admissible?
Your Honor, I believe that would be admissible. Under Mosley, we see some of the factors that are necessary for a Miranda waiver, such as having this attenuation, waiting a reasonable time, re-administering of Miranda waivers, and then reinitiating and waiving those rights. Those are considered ways to cure the taint of a Miranda violation. But to bring us back to this legal question, it's about whether just the invocation of the right to silence categorically mandates exclusion of subsequent statements. And what the appellant is asking for is this bright line exclusion, no matter whether there was a Miranda violation at all. I think that's an extremely broad rule that threatens to cut off a long considered legitimate investigative tool of the police.
Well, I don't hear a bright line rule being argued by appellant. They're arguing that under the unique facts of this case, the statement should be suppressed.
Yes, Your Honor. And I would disagree also on the facts of this case that this statement should be suppressed as well. I think we can also look to the other California case law on this issue, and ruling in favor of the appellant would be a break in all California legal precedent here, also a break compared to other states who have ruled on this issue. There's no specific binding precedent here, but California courts of appeal have unanimously held that Miranda does not apply where defendant invokes their Miranda rights before talking to someone that they did not know was a police agent. And there are also California Supreme Court cases, such as People v. Webb, that hold that. And so these are very factually similar cases. And even in the more protective right to counsel circumstances, still the courts are holding that these statements are admissible because there were not pressures attendant to speaking with law enforcement. And the California Supreme Court has denied cert on this issue multiple times.
Well, what is it? Well, you mean they denied review, but in any event, what does that show? What does that prove?
Excuse me, they denied review. I believe that proves if they thought there was a significant legal error that was being committed, they could have taken this up earlier, and they have chosen not to. Of course, they could always choose to take it up in the future.
Yes.
Further, I think if we think about just the broader implications of exclusion of these Perkins statements, like I said, it won't allow for any good faith mistakes on the part of the police. For example, if a suspect invokes the right to silence upon arrest, then ruling that any time the right to silence is invoked means categorical exclusion would call that those statements would be excluded, and law enforcement would not have the opportunity to either do a formal custodial interrogation in that instance or to do a Perkins operation. And that feels not in line with the holding of Perkins and with the tools of the police in general.
Let me ask you this, counsel. Is there any facts in the record that show that the interrogating officers or their department, the prosecution team, let's call it, had anything to do with depriving Mr. Prescott of a shower, of his phone call, those various rights that he has under statute? Is there any evidence to show that they manufactured those events in order to, in other words, pile on the coercion here?
No, Your Honor, I don't believe that there's any indication of that in the record. And I believe perhaps this is speculation, but the 3 days between the time of the initial violation and conducting the Perkins may just have been that Detective Hayford was speaking with the prosecution. He realizes he could not use that initial confession, and he needs to figure out a new way to get the evidence of this murder case to the jury at trial, as the prosecution requested. And that takes time to coordinate that change and to conduct the Perkins operation. And so I don't think there's any suggestion of bad faith here. I think if Detective had looked to Supreme Court case law or California case law on this issue, he would have rightfully understood this to be a lawful approach to solve the issue of the Miranda violation.
And Mr. Prescott had the opportunity in the trial court to bring those facts on if they existed, correct?
Yes, that's correct. Yes.
Ms. Mueller-Shaw, you have 2 minutes remaining.
Thank you. I spoke earlier about courts in other states. There are at least 5 other states. Again, this is all persuasive, but that have held that invocations of Miranda rights do not dictate exclusion of Perkins states, and that's been held in Arizona, Illinois, Florida, Missouri, and Alaska. And on the other hand, there's only one state, which was Nevada, that disagrees. And to do that, the Nevada Supreme Court had to abrogate Perkins and tie its holding under the Nevada state constitution. However, here in California, since the passage of Proposition 8 in 1982, the California Constitution offers no more protection than the federal Constitution for criminal confessions. And so that avenue in finding an abrogation of Perkins is not available to this court. I think, in addition, I think we can return to the Miranda waiver doctrine and think about what Perkins holdings means in this case. Applying the Perkins waiver doctrine would be inconsistent both with Perkins and California case law. As I mentioned, Perkins held that undercover operations are not official interrogations under Miranda, and California courts of appeal, including a People v. Guillemette, held that if a custodial interrogation is lacking, Miranda rights are not implicated, and there is consequently no occasion to determine whether there has been a valid waiver. So Miranda doctrine under Perkins, under California law, just does not apply. And if you don't have those Miranda rights, it logically follows you don't need to waive them. So in closing, we should not deter law enforcement from doing their investigative duty when a defendant chooses to trust someone and confess. And we respectfully request that the court deny this appeal and affirm the trial court's ruling to admit the Perkins transcript. Thank you.
Thank you, counsel.
Ms. Watson, you have 15 minutes.
Good morning, Your Honors, and may it please the court. My name is Landy Watson, counsel for respondent, the people of the state of California. As my co-counsel described, today's case is about the absence of police coercion. Mr. Prescott is a veteran of the criminal justice system who boasted to an undercover agent 3 days after the police's initial Miranda violation. The incriminating statements to the undercover officer were properly admitted both because they were voluntary and because the fruit of the poisonous tree doctrine did not mandate their suppression. Turning to the first part of my argument, Mr. Prescott's statements to the undercover agent were voluntary. The Supreme Court in Mincy v. Arizona held that a confession is involuntary if it is not the product of a rational intellect and a free will. This is assessed based on the totality of the circumstances. And the California Supreme Court in People v. Bradford put a finer point on it when it held that any finding of involuntariness must include a finding of police coercion. But police coercion itself is not even enough to make a statement involuntary. And here, the appellant must also show a causal link between police coercion and the subsequent statements to the undercover agent, which they are saying should have been suppressed.
So, Ms. Watson, what about the fact that the police agent in this case was, for lack of a better word, prompting or probing for additional information? It's not like that person was sitting silently listening, and being a shoulder to cry on and a good listener. That person was prompting and asking for details, and when those details were not forthcoming, reprompting to saying, well, how did it go down? Like, it seems to me that there was more than just sort of a passive listening going on here.
Yes, Your Honor, this was a conversation. It was not mere passive listening, but that change in the facts doesn't change the legal analysis, because even in Illinois v. Perkins, which we've discussed extensively here today, the undercover agent in that case asked the suspect, have you ever done anyone, or something to that effect, asking if he had ever committed a murder. And that is the case in which the Supreme Court held that where it's an undercover agent, there's no risk of coercion that the Miranda court was concerned about. And so here...
Go ahead,
yes,
I'm sorry.
Here, the totality of the circumstances demonstrate that Mr. Prescott's statements were voluntary because there was no threshold showing of coercion from the appellant today. So first of all, the initial Miranda violation in and of itself was not enough to show coercion in this later conversation. And the California Supreme Court held something very similarly in People v. Bradford, where there were repeated violations.
Ms. Watson, what if the initial Miranda violation had taken place 24 minutes ago instead of 3 days ago? Would that change your analysis at all?
Your Honor, if the Miranda violation was in very close proximity and there was a deliberateness to the Miranda violation, perhaps the Supreme Court's holding in Missouri v. Siebert could suggest that those statements would be inadmissible. But here we don't have 24 minutes, we have 3 days. And opposing counsel pointed out that there was no break in custody for Mr. Prescott. But Mr. Prescott was a murder suspect. He was facing very serious charges. And so this was not an option for police. But what police did do is they stopped interrogating him and they let him go to his cell. And there was nothing particularly unusual about Mr. Prescott's experience in custody.
What about the fact that he was not permitted to make a phone call? He was not permitted to shower, as apparently was his right. And I actually learned something today that's a statutory right. I did not know that. But all of those things combined, doesn't that sort of add to the side of the scale where we're looking for coercion? I mean, he wasn't put in a hotel suite to wait. He was put in a jail cell, not allowed to make a phone call, not allowed to shower. I mean, aren't those coercive indicators or indications of some type of coercion?
Your Honor, I would like to answer your question in two ways. First, addressing the legal question here and precedent, and then also addressing the actual facts of this case. So the California Supreme Court has set a very high watermark for where deprivation in custody can lead to statements being involuntary. And in the case of People v. Neal from the California Supreme Court, the suspect there was deprived of food, toilet facilities, and was not given anything to drink for over 24 hours. And that is the level of extreme deprivation that, in combination with many other factors, led the California Supreme Court to find that those statements were involuntary. Of course, that case also did not involve an undercover agent, which also attenuates some of the taint from that initial.
Let me ask you this, counsel, to add to my fellow justice's question. Here, you've admitted, and the appellants have asserted, that this wasn't Mr. Prescott's first rodeo. In other words, he had been in custody before. So doesn't that factor in the sense that in prior instances, he probably got his phone call, he probably got his shower, and now he's held for 3 days and deprived of those things? Wouldn't that suggest to him, to any reasonable person, that he's not being treated fairly, that he's not going to have his rights honored? And therefore, when someone, an undercover agent, very skillfully questions him, doesn't that feed into their argument that this, in fact, was a coerced statement, involuntary as a matter of fact?
Your Honor, I believe that Mr. Prescott's experience in custody actually cuts against appellant's argument, because the subjective characteristics of a suspect are also part of the voluntariness analysis. And in People v. Neal, the court was very focused on the fact that the suspect there was 18 years old and never had any involvement in the adult legal system. And as you pointed out, and as you characterized it earlier, Mr. Prescott seemed to know what he was doing, and that's reflected in the record as well. On page 156 of the Perkins transcript, he talks about being in jail multiple times. On page 160, he tells the undercover agent, when the undercover agent asks, like, "Oh, you didn't say anything to police, right?" He says, quote, "We know better than that. This ain't our first time." And that's on page 160. And so Mr. Prescott's experience with the justice system also suggests that any elements of coercion or deprivation would weigh less heavily on him than it would on, say, the suspect in People v. Neal. But I also want to address the appellant's characterization of Mr. Prescott's time in custody. While it is true that defense counsel stated at the motion to suppress that Mr. Prescott did not get a shower and did not get his call, on page 202 of the Perkins transcript, Mr. Prescott did tell the agent that an officer had told him that day that he was going to get to use the free phone that day. And it's not like Mr. Prescott was in custody for weeks. He was in there for a couple of days. And like Justice Weiner said, he wasn't in a hotel suite. He was in custody as a murder suspect, and sometimes that can be an unpleasant experience. But this court's job is not to assess whether it was unpleasant, but is rather to determine whether there was a causal link between police coercion and the statements that appellant is arguing should have been suppressed.
Counsel, let me ask you this. Obviously, Mr. Prescott and his counsel argued to the judge at the suppression motion that his statements were coerced, correct? Factually,
yes, Your Honor.
Did he further make that argument to the jury and offer evidence of that?
Your Honor, that specific argument, I don't believe, was made at trial. There was, and I don't have the record site for you, unfortunately, there was a suggestion when Detective Hayford took the stand. There was a question about whether or not the undercover agent might have been built like an NFL linebacker or something, maybe suggesting that the size of the agent would have made this coercive. But I don't think that goes to appellant's argument, which is that it was the initial interrogation and the incidence of custody that made the later statements coerced.
Okay, but we have to assume then, for sake of argument, that the jury found the statement was voluntary and considered it in finding him guilty, correct?
Your Honor, I don't know if we can assume that the jury specifically relied on that piece of evidence, but there was not argument as to, or evidence introduced that suggested that the statements were involuntary. And here, the appellant has failed to show the causal link between the initial interrogation and the subsequent statements. And I think that is really the crux of the case today. Justice Cody, you asked about how that initial interrogation really affected these later statements, and these statements were made to an undercover agent, and there's nothing in the record to suggest that Detective Hayford gave any information to the undercover agent that informed their questioning.
5 minutes.
Thank you. Thank you.
So I'm
And so,
counsel, that there, correct me if I'm wrong, that there are certain Perkins operations that that might be invalid or that might result in suppression of statements, depending upon the circumstances. For example, you said in response to one of my fellow justices' questions that if the statements at the operation had occurred minutes after the original Miranda violation, that might make a difference. So you, again, I think I'm correct in summarizing that you do believe there are certain Perkins operations where there might be a violation. Is that right?
yes, Your Honor, I do think it's possible for a Perkins operation to produce involuntary statements that would be inadmissible. I think that was the holding of Arizona v. Fulminante from the U.S. Supreme Court, but there it was extreme threats of physical violence, and the suspect there was actually experiencing physical violence, excuse me, and was offered protection, and that's simply not the case here. And your question turns me to addressing the appellant's second argument under this issue 2, which is fruit of the poisonous tree. And appellant relied heavily on the case of People v. Montano to suggest that a mere Miranda violation would make later statements inadmissible. But the California Supreme Court in 2 cases, People v. Storm and People v. Bradford, foreclosed that argument for the appellant, because in both of those cases, the California Supreme Court found that even where there is an initial Miranda violation, the appellant or the suspect must show that the later statement was involuntary in order for it to be suppressed. And these cases fall in the Oregon v. Elstad line of cases from the U.S. Supreme Court, where the Supreme Court very clearly said that they would not extend the fruit of the poisonous tree doctrine from the Fourth Amendment context to mere Miranda violations, and said that a Miranda violation did not make later statements inadmissible.
Well, what about what he said to the police after he invoked?
Your Honor, sorry.
The actual statement that he made.
Your Honor, the statement that he made in the initial interrogation was suppressed. And I would also like to contest appellant's assertion that the fact that it was stipulated that those initial statements wouldn't be admitted suggests anything about the underlying Miranda violation, that it was more egregious or anything like that. Because any statement that's made in violation of Miranda in a custodial interrogation setting cannot be admitted. And so the failure of the prosecution to seek to admit those statements was just in line with the law of Miranda, that those statements could not be admitted.
But for purposes of fruit of the poisonous tree, can we not look to the circumstances, the overall circumstances of the Miranda violation?
Your Honor, I believe you're suggesting that maybe this wasn't just the Miranda violation, but a sort of Miranda plus where there were other elements. However, as I argued earlier, the totality of the circumstances don't demonstrate that this statement in the undercover operation was the result of police coercion. Rather, the record shows that it was the trust that the Perkins agent established with Mr. Prescott over the course of an hour-long interrogation that led him to confess.
1 minute.
And so the appellant hasn't shown any connection between the statements made in the initial interrogation or any of the factors that were any of the elements of his time in custody, has not shown any connection between that and the later statements to the undercover agent. And so I believe that the fruit of the poisonous tree metaphor or doctrine does not aid appellant in their argument. And even if we do look to a case like Missouri v. Siebert, there it was deliberate police action to violate Miranda in the same custodial interrogation. And so ultimately, the largest source of attenuation in this case is the fact that the later statements were made to an undercover agent who Mr. Prescott, from his perspective, had no reason to think was a police officer. And so ultimately, as my co-counsel described, coercion must be measured from the perspective of the suspect, and there's nothing to suggest that Mr. Prescott was facing police coercion in that undercover questioning that would have made his statements involuntary.
Well,
and therefore we ask.
You're out of time.
Sorry, can I briefly finish my sentence?
Yes, go ahead.
Thank you. We ask that this court deny the appeal. Thank you.
Ms. Dutcher, you have 4 minutes of rebuttal.
Thank you. Counsel for the respondent suggests that our argument relies heavily on the fruit of the poisonous tree doctrine. But as Justice Jones correctly pointed out, that is not the basis of our argument. Rather, what we're asking this court to adopt is the analysis set forth in the case of People versus Williams and the California Supreme Court, where the court said that in the context of a Miranda violation, the issue with respect to the admissibility of a subsequent statement rests upon whether that statement was voluntary. Additionally, counsel suggests that Orozco is illustrative in this case, but there are some factual distinguishing points to be made based on that case. Specifically, in People versus Orozco, there was a single Miranda violation, and the course of misconduct was in the course of 3 hours. That is simply not the case in Mr. Prescott's case. The court addressed voluntariness in that case based on a single Miranda violation when the detectives did an undercover operation after he had invoked his right to counsel. That is simply not the case in Mr. Prescott's case before us today. Mr. Prescott invoked his right to silence, and law enforcement deliberately continued questioning him thereafter in violation of his Miranda rights. Thereafter, in the same interview, he was subject to an improper threat when he was told that unless he comes off of his invocation, he will serve a life sentence. Additionally, he was given an improper promise of leniency, which the court in People versus Neal ruled, no matter how remote, is corrosive to voluntariness. Additionally, he was deprived of a phone call, which is a violation of California Penal Code Section 851.5, and then he was also deprived of a shower, which was a violation of Penal Code Section 2084.3. Counsel also
aren't the
suggested
facts in Orozco, don't they actually hurt you because they're the Perkins agent, the girlfriend or mother? They had that conversation 3 hours after his Miranda rights were violated. In this case, 3 days had passed since the Miranda violation. So doesn't that factual distinction actually work against you?
It may, Your Honor, assuming that there were no other coercive police activity over the course of the 3 days during which the suspect was incarcerated. And that is the scenario that we have in this case.
Well, counsel, okay, was there any effort to show that the denial of the shower, denial of the phone call, et cetera, was manufactured by the investigating officers, by the prosecution team?
I wouldn't suggest that it was manufactured by the prosecution team, but the burden is on the government to obtain evidence to establish their burden of proving guilt on behalf of the defendant. And counsel for the respondent has suggested that the deprivation could have just been because Detective Hayford was trying to gather evidence.
But wait a minute. They have the burden of proof to prove he was guilty of the offense in a jury trial.
Right.
But wasn't it your burden to show that there was coercive elements, such as the prosecution team, manufacturing the coercive environment?
1 minute remaining.
No, because the inquiry rests upon establishing that there was a causal connection between and rebutting a presumption that the California Supreme Court proffered in the case of People versus Jones. The prosecution have simply failed to rebut the presumption that the Supreme Court put on them to rebut, to say that the improper influence of an initial Miranda violation did not have any causal connection between the defendant's decision to incriminate himself. In that case, the court specifically ruled that there's a presumption that the influence of improper treatment continues to operate on the mind of a criminal suspect, and that his or her subsequent statement is of the same influence which rendered that prior statement inadmissible. And the prosecution have simply failed to rebut that presumption. Mr. Prescott was subject to a coercive pattern of police activity to the extent that his ability for self-determination by the time the Perkins agent came into his cell was critically impaired. We must evaluate the totality of the circumstances during which a suspect gives incriminating statements pursuant to the California Supreme Court case of People versus Williams. And when we couple the evaluation of the totality of the circumstances with this presumption that the California Supreme
Counsel,
Court
I
has
think you're out
given,
of time.
oh, may I conclude?
You can finish your sentence.
For the foregoing reasons, I respectfully ask this court to rule that Mr. Prescott's statements were admitted at trial erroneously, and I ask this court to reverse the ruling of the trial court. Thank you.
Thank you, counsel.
Thank you.
All right. That concludes the argument for this morning. As I described, the justices will be conferring offline. And while they do that, I wanted to congratulate everybody today and yesterday. We hosted over 20 competitors yesterday, 12 judges, and many, many observers from all over the state in our preliminary rounds yesterday on Saturday. And it was all on Zoom. It was a very exciting, gratifying day. As much as we enjoyed experiencing this competition in person before 2020, doing the Traynor virtually has really improved the affordability and the accessibility and the inclusivity of this competition. So we're so happy that we were able to gather from all over the state to carry out the Traynor again this year for the 56th year. A huge part of our success this weekend was due to our host school, the University of West Los Angeles School of Law. Robert Brown, president. Jay Frickberg is the provost and dean. And Jesse Aldava, Mauricio Cana, Chris Kukta, and Hamid Taf from Library Services all worked with us virtually and on site to be able to put on the competition. We also send out a big thank you to our able and dedicated student and alumni bailiffs who took time from their busy lives to help us run the rooms and run the competition and support everything that we do at the Traynor. I also want to thank all of the judges who volunteered their time and energy and expertise to this event. And finally, the Traynor was made possible by a generous grant from the Gisnet Mandel Moot Court Trust. So special thanks to that organization and Patrick and Ingela Pigot for helping us with that. And those are my thank yous. I wanted to let you know that we do publish a program for the competition. So that will be available on the Traynor website. There will be a synopsis of the case there, information about the Traynor, the list of all the winners that I'm about to announce. And there are also past winners there. And you can watch past arguments, final argument rounds there. Everything can be found on traynormootcourt.org. Today's argument has been recorded and will be posted there as well. The Roger J. Traynor Award will go to the winner of this morning's round. So we have to wait to hear what the justices decide for that. But while we wait for them to confer and decide a winner of today's round, I am very proud and excited to award the Gisnet Mandel Award for Best Brief to Berkeley. The second place in the Best Brief Award is Empire, and third place goes to UWLA. The Excellence in Appellate Advocacy Award is awarded to the team with the highest combined total score as follows: 50% for the brief, 50% combined oral argument score in the first 2 rounds from yesterday. And that has to be from a school in the top 50% of both of those. And the winner of the Excellence in Appellate Advocacy Award with all of those criteria is Berkeley. Second place goes to Empire, and third place, UWLA. And finally, we have awards, individual awards for excellence in oral argument. First, we have the Jeffrey Hall Wright Award for Best Oralist. When you check out the program that is published on our website, there is a biography of Jeffrey Hall Wright, who is the advocate for whom this award is named. So I hope you take a look at that. This award for the best overall performance on Saturday's rounds is Lillian Dutcher, and she is from Empire. The individual merit awards for oral argument are as follows: Landy Watson, Berkeley; Patrick Ogilvie, Kern County; Kaylana Mueller-Shaw from Berkeley; Gina C. Herring from UWLA; Veronica Reynolds from Loyola; Sophia Turgeman from Loyola; Faith Magbaro from Berkeley; Simon McMurtry from UCLA; Haley Borgia from UWLA; and Cassandra Vo from UCLA. Congratulations to everyone who won an award, and congratulations to everyone who participated in the 56th annual Traynor Moot Court Competition. All of these results will be posted on our website as soon as we are able, along with a recording of this final round. Congratulations again. So I'm going to take a pause, step away, and see where they're at in tabulating the results from today's competition. I will be right back. Welcome back. The justices have conferred, and I turn over the floor to them.
Okay. Well, that was amazing. And what we've decided to do is to go in, take turns and make comments on what the justices saw, their opinions about how you did, and then I will conclude with announcing the winner. So we'll start with Gary Shans.
Thank you, Justice Cody. As you might be able to tell, unlike my esteemed colleagues, I am neither a justice nor a judge and never have been. But that said, I was a member of the Attorney General's office for 35 years in the criminal appellate writs and trials section. And for the last 20 years, I was in charge of the San Diego office. And after that, I went to the district attorney's office for 3 years as a senior advisor. And then I spent the last 7 years in a private firm doing public law, municipal law, as it's called. And I've had a long experience with Moot Court, and I've had the opportunity to argue in, I think, every appellate court in California, the U.S. Supreme Court and the California Supreme Court. So that's what I brought to it. So against that, I want to say that in my many, many years of doing Moot Court, I don't think I've seen presentations as well done as what I heard this morning, particularly the balance between the teams. I mean, it's extremely difficult to distinguish between the 4 of you or the 2 of you as team members or couples in this, in determining who did the best job. I thought all of you were well prepared. You obviously were familiar with the facts of the case and the law that applies here. I think our questioning, if anything, is of benefit to you because you've now experienced what a court of appeal in particular, be it an appellate court or a Supreme Court, is going to care about and ask about when you present your case. I think for the most part, you did an excellent job in realizing that and having the ability to point to the record that was made below, the facts of the case, and to the relevant precedents of the courts that apply here. I think the only thing I would have thought of on behalf of the appellate is to perhaps to argue that this court, even though we're the Court of Appeal, we're not bound by the Orozco case. We can disagree with it, and that occurs not infrequently, not commonly, but not infrequently in the California court. So that was one sort of claim I was looking for that I didn't hear, but I mean, that's neither here nor there. But I thought it was of some interest that there was no argument made that Orozco was incorrectly decided. Maybe you agree it was correctly decided and just determined to distinguish it, which is another way to go after it. And for the respondents teams, again, I think the difficulty you had was sort of the difficulty I had, which was distinguishing in the Ms. Mueller-Shaw's argument as to what you were really countering from the other side, because I think the appellant sort of blended in between Miranda and Perkins and then involuntariness as a factual matter. And that made your argument a little more challenging. But overall, I thought you did an excellent job. And as I said, all four of you as presenters, whether moot court or, as I'm sure a year or so from now in a real court, you will be arguing, and I'm sure you'll do as well there as you had today. And I congratulate you, number one, on participating in the first place in these competitions, because I know how much work goes into it before you ever appear. And then also, obviously, that you've succeeded to the final round. So congratulations to all four of you.
Thank you, Mr. Johnson. Judge Weiner?
All right. Well, good. Is it afternoon yet? Not quite. Good morning, everybody. So my name is Judge Tim Weiner. I feel like I'm the inexperienced person because I only had 15 years at the Attorney General's office in the appeals, writs, and trials section. And while I also got to argue in every court, I did not get to argue in the U.S. Supreme Court. So I feel like I'm still have a ways to go, Gary, before I'm at your level. But it's a fantastic opportunity there. I've been a judge since 2016. I started as a commissioner in 2016. I was appointed by the governor in 2018. I'm now the supervising judge of the Southwest District in Los Angeles County. I have criminal and I'm currently in a family law assignment. So I echo the comments of my colleague. I thought this was an amazing final round. The teams, I judge moot court all the time, and oftentimes you will see this, where there's one team that's just so obviously ahead of the other team, and that was not the case here. I thought that the appellant and respondents teams were both obviously so well prepared, had such a great understanding of the record. I do have some individual comments. I hope you'll indulge me. Ms. Milks, I thought that that you're, oh wait, I think I may have these back. No, here we go. Yeah, here we go. I thought that your pace was excellent. I thought that the way you're one of the things that happens all the time in moot court in particular, but in court in general, is people will talk so fast that you just can't even hear their argument. They may have the greatest argument in the world, but they're talking so quickly, you just can't follow it. And you had an excellent pace. You spoke clearly. You had excellent demeanor. I thought you did some things that really added a lot of balance to your credibility bank account. You acknowledged there was some authority out there that wasn't great for you, and you came right out and acknowledged it. And I think that is so important to do. You had great timekeeping skills. I'm just reading my notes here I took, and I thought you had excellent citations to the record. So really nicely done. Ms. Dutcher, you did something that I just love in my own courtroom. You came in and out of the gate, you asked for specific relief. You told me what you wanted out of the gate. And it's like, oh, thank goodness, because so many times, like, people bury the lead of what they're really looking for. And I just thought it was so nice that you did that. I'm gonna give you not that there's anywhere else to go. You've already reached the top of this competition, but I'm gonna give you one piece of sort of moot court forensic advice, and this is coming from a former mooter. I was on our moot court board of governors, and I love moot court. For me, rebuttal is the greatest thing in the world. I told my colleagues in our call, I said, to me, it should just be a stab in the back, though. You asked for 4 minutes, and when I heard that, I'm like, oh, Gary's gonna ask her lots of questions, I bet. You know. For me, I would ask for like 1 minute, maybe 2 minutes. And you go in with 1 or 2 points and you go, God, the respondent said this, and boy, were they wrong. And here's why, and then run, right? Because they don't get to respond to that. And when you had all these points you wanted to make, and I'm like, oh, there's no way Sean's is not going to ask questions in 4 minutes. That's just not possible. So that is such a ticky-tacky point, though. But I mean, you're so excellent. I'm going to give you that little tiny piece of advice, but I thought you did a fantastic job. Let me switch over to respondents team. I thought the respondent probably had the easier argument to make, just based on the state of the Supreme Court authority. And Ms., am I pronouncing your last name correctly, Ms. Mueller-Shaw? Thank you. I thought that you did such a good job at sort of moving the court, because we were kind of peppering you with some stuff a little bit. And you did such a nice job at sort of bringing us back on topic and kind of gently focusing our attention on what you thought were the most important points of your case. And that, I don't know if you know this, but that is a real art, because you don't want to offend a bench, right? You don't want to be like, Judge, that's not the important thing here, because what's important, let's be honest, it's what these 3 people say is important, right? I mean, I can remember many cases in the Court of Appeal where I went in and said, God, this is for sure going to be a Miranda issue. The court couldn't care less about the Miranda issue. They wanted to talk about something that I was only vaguely prepared for, right? So, and you learn that it's what the bench is interested in. That's what's important. And I thought you just did a really good job of addressing that, but still bringing us back to the things that you wanted to talk about. Excellent record citation. And I think, and correct me if I'm wrong, I think maybe you kind of said what you had to say and you had some time left over. Is that true? Yeah. So I thought it was an outstanding use of your extra time. I'll call it extra time when you started talking about persuasive authority, because in the heart of the argument, no one cares. That, you know, in the core of your argument, if you come out of the gate talking about what Rhode Island does, you're going to get a bunch of eye rolls from the bench, right? But you got through everything you needed to talk about. You realized you had a minute or 2 left, and then you started talking about this persuasive authority, and it was so well done. Like, I just thought it was a really excellent sort of forensic and technical way to get that argument in. So really nicely done. Ms. Watson, I think you got pushed around a lot and you pushed right back. I thought you did a great, I gave you a hypothetical, you know, about the 24 minutes versus 3 days. And I think you dug right in. I thought you had a really great knowledge of the case law. I liked how you distinguished Neil about the 18-year-old being so inexperienced versus, I think it was Perkins or whatever, that somebody who's really familiar with the system. And I thought that was really effective in response. I'm trying to read some of my notes here. Oh, the one other forensic thing I thought you did a really nice job of is the presiding justice asked you a question. And after you answered the question, you used it to segue into another point you wanted to make. And you said something along the lines of, and in answering your question, this brings me to this other point. And it was just a very, I hate this term, but organic way of moving the conversation to something that you wanted to talk about. And again, that's just a real art. That is a skill. I will tell you, I mean, I'm in court every day. I'm on the bench every day. I wish the attorneys that appeared in front of me were as skilled as the 4 of you. You are all outstanding. I have no doubt you will become outstanding attorneys. You are already outstanding advocates. You should be very proud of your accomplishment today. And thank you for making this a really, just truly enjoyable final round to judge.
Thank you, Judge Weiner. I don't think I could say anything more eloquently than the two of our other justices have already said. And I'm terrible at taking notes while argument is going on, so I'm not going to have individual comments. I think I'll stick to the global comments, which is, again, I echo what has already been said. You all were amazing. I think the appellant had the more difficult position, and as a result, I think had some of the more difficult questions and were peppered a lot with questions, especially Ms. Milks. And I really was impressed with how you stayed on not your script, but because I'm sure you've all learned, and none of you did it. You didn't read from a script, which would be awful. But you certainly have notes, and I can see that you've got an outline that you want to follow. But when you get hit with questions that are at the last page in your outline, I thought you did a really good job of coming back to where you wanted to go. And frankly, I think everybody did that. And I think that's some of the earlier comments I heard. The questions need to be answered, but you then, all of you were able to get back to what you thought was important. But I also think you didn't just say, well, that question wasn't important. As I think Judge Weiner pointed out, you used the questions to then segue into a part of your argument that you thought you needed to emphasize and show us how significant some of the issues were, despite maybe you thought us going off on tangents that you might not have thought were as important to your argument as we might have thought they were. So I thought you all handled those well. I was so impressed. I mean, are you all third-year students? Is that where we're at? Yeah. No, second? Oh, wow. Okay. Well, amazing. I should have started out with who I am. I'm Justice Cody. I am on the 2nd District, 6th Division Court of Appeal. I had very little criminal experience before I came to this assignment, having sat in a superior court in Ventura County for 22 years, doing primarily dependency, which, if you don't know, is the child abuse cases. So I had some criminal experience, but not a lot. So I even though Mr. Schoen says he hasn't been a justice or a judge, you wouldn't have known that from his questions. And Judge Weiner has all the experience that he has, having served in the AG's office, plus being on the bench. So I feel like I'm actually the new person on the block here, even though I'm on the Court of Appeal. So I was impressed with how you responded to some of those very difficult questions, all of you. So I congratulate you for getting this round. I know how difficult it is. Having seen some moot courts, I haven't done very many. This is my 2nd year doing Traynor, so I'm very impressed with the caliber of students that I'm seeing in these competitions. So I don't really even like this part of doing moot court or mock trial because I have to announce winners, and I never like doing that. This was so close because you all did such an amazing job and were so well prepared. And I'll just step back a minute too. I love when you cite to the record, all of you. It tells me you know what the facts are and you get the facts right. That's so important to me, especially at my job now, is that we get the facts right. And then to also cite 2 cases that you felt like were supportive of what your argument was, pretty much, at your fingertips. I really thought that was very
Justice Cody, if I may please interrupt just briefly. Yes. And I just want to elaborate on that. It was an appropriate citation to the record, an appropriate citation to case law. It wasn't this sort of gratuitous, hey, I'm in moot court, and one of my professors told me last week I should cite to the record, so I'm going to point you to page 36 of the record, and it's totally irrelevant to my point, but look at what I'm doing. I'm citing to the record. I thought it was just very appropriate use of those citations, which sometimes, having judged a lot of moot courts, it's not. And I thought that the way it was done here was really the impressive part. Forgive me for interrupting.
No, and I think you said it better than me, but you did remind me of something that I see even now when I hear real argument in the Court of Appeal. I'll hear an argument where they spend their time citing to the record, and that doesn't necessarily help me. I don't want to be impressed with how well you know what's on page 153 of the record. I want to hear that is in response to, for example, a question that's been asked, and you're showing us this is what the facts are, and here's where you can find those facts. So yes, it wasn't gratuitous at all. It was very responsive to the questions that were being asked. And I find that very helpful, and it gives you a lot of credibility when you make your arguments. So, well, with that, Judge Weiner and Mr. Schoens, anything else you want to add before I have to do the hard job of announcing the winner?
Oh, ma'am.
Just again, congratulations to the competitors.
Congratulations.
Much so. So we felt on balance that the respondents team did a better job, maybe because the issues were a little easier, but again, you all did such an amazing presentation and were so well prepared, but ultimately we ruled in favor of the respondent. So congratulations.
Congratulations to both teams for making it to the final. Congratulations to all the teams that competed yesterday. It was a very close competition. Everyone did really well with a challenging case. I want to thank the justices today for a wonderful final round and such great comments. I was taking notes for my own self. So this recording will be posted on the website. So you have it as a memory, and anyone who is getting ready for a moot court competition should be using this as a primer. So thank you everyone for your time and your effort. And we will see you next year. Thank you once more to Professor Glassman for his support and for acting as bailiff today. Thanks, everyone.